Hi viewers, I'm Abhilash Nayak. Welcome to my channel Legal Thinkers. Today we shall be discussing about various types of property frauds. Before that, please hit the subscribe button and please share this video with all your friends and families. Thank you. Today's topic is Hindu women's rights over ancestral property. Please remember this timeline, 9 September 2005. On this date, Amendment to Hindu Succession Act 1956 happened, which says that any partition which has been made prior to this date for father's self-acquired property and also father's ancestral property after his death. In such a scenario, that partition stands valid if daughters are not included. Daughters cannot claim a share in such partition made prior to 9 September 2005. If any partition which has been made after 9 September 2005, in such a scenario, if there is no registered will, in such case, woman can always claim a share in ancestral and also self-acquired property of his father after his death. Stridhan concept. Before 9 September 2005, it was considered woman to be part of the other household where she is getting married. So she severs her ties of her parental home and she becomes part of the other home where she is getting married into. But in today's date, women are also taking care of their parents even after getting married to another person. In such a scenario, Supreme Court considered that women should also get equal share in the property. So this timeline, why they have put a timeline? Because otherwise, if timeline is not put, otherwise courts will be pending with lakhs of litigation cases. Given a timeline of 9 September 2005, after which if any partition has been made where there is no will or any other documentation existing in favor of the daughter, in such a scenario, daughters can always claim a equal share along with their brothers in ancestral property, self-acquired property of her father after his death. Today we shall be discussing about rights of married daughters over ancestral property. In the earlier video we discussed about rights of Hindu women over ancestral property as per amendment of Hindu Succession Act 1956. In this scenario, dear friends, if father's death occurred before 2005 plus and daughter is married before 2005, in such a scenario, if any partition has happened even after 2005, married daughter shall have no right over father's self-acquired and ancestral property. So two conditions: death prior to 2005 plus marriage prior to 2005. In such a scenario, married daughter cannot have any rights over father's property if partition has to happen after 2005. So what is the scenario for death after 2005? If father's death occurs after 2005 and if no registered will exists, in such a scenario, married daughter has equal rights with other sons during partition of property. Any partition has to happen after 2005 and father's death has occurred. In such a scenario, partition has to be made equally along with other daughters. Thank you. Hello viewers. The information supplied in this YouTube channel is purely for information purpose only. This should not be an alternate for any legal advice or expert legal opinion. Please consult any expert advocate in your vicinity and please get your documents verified before investing in any apartment, land or even a plot, and save your hard-earned life earnings for your future use. Save your court battles and litigation. Please hit the subscribe button and please share this information with all your friends and families. Thank you.